We got some breaking news. Two separate federal judges, Judge Murphy in Massachusetts, Judge Quarashi in New Jersey, 24 hours apart, have both ruled, this is outstanding, that the Department of Justice, Department of Homeland Security, the Trump administration have not only consistently and illegally violated the due process rights of migrants they have captured and tried to remove, in one case, to third countries, but in addition, they have done so in clear violation of federal judge orders, lying to federal judges, submitting false evidence, and they've had it. And what we're watching as I outline these two different cases by two different judges on the same thing is how federal judges are using their tool bag in year 2 of the Trump administration in ways that are more powerful and robust and more willing to go there to rein in a lawless president than they were in the first year. And that's a good thing. I'm Michael Popak. Where are you? You're on Midas Touch and on Legal AF YouTube channel. Let's start with Judge Murphy. Judge Murphy, how do I put this kindly, got lied to by the federal government in when the federal government tried to remove to foreign countries people that the judge had ordered needed to stay put in the United States under federal judge oversight until he had made his rulings, and then lied to the federal judge and lied to the United States Supreme Court. In fact, Murphy says in his own order, 81 pages, that effectively the government lied to the Supreme Court. That is shocking. Let me read to you from his order about this issue. It has to do with people being removed to countries like Morocco and Somalia and third countries and all of that. And at bottom, this third country removal, like we don't want them here, we're going to send them to another country that they have no connection to. Like trying to send Kilmer Abrego, instead of to Venezuela, try to send him to Cameroon or Liberia or places like that. Here's what Judge Murphy has to say. This case is about whether the government may, without notice, deport a person to the wrong country or a country where he is likely to be persecuted or tortured, thereby depriving that person of the opportunity to seek protections to which he would be undisputably entitled. The Department of Homeland Security has adopted a policy whereby it may take people and drop them off in parts unknown in so-called third countries. And as long as the department doesn't already know that somebody's standing there waiting to shoot, that's fine. It's not fine, Judge Murphy says, nor is it legal. Congress made it the policy of the United States not to expel, extradite, or otherwise affect the involuntary return of any person to a country where that person would be in danger of being subjected to torture. It may surprise the reader, Judge Murphy says on page 2 of his order, that in its most candid moments, the government agrees. As recently as March 24th, during the pendency of this very litigation, the Department of Justice told the Supreme Court we would have to give the person notice of the third country and give them the opportunity to raise a reasonable fear of torture or persecution in that third country. This was not a remarkable admission, but rather a well-established, decades-old application of due process principles. But less than a week after that above-quoted comment to the Supreme Court, this is the first of 2 lies to the Supreme Court that Judge Murphy calls out. The Department of Homeland Security changed its position and issued a new policy. And this is the policy in March of 2025 that Judge Murphy has now permanently blocked. This new policy, on page 3, which purports to stand in for protections Congress has mandated, fails to satisfy due process for a raft of reasons. The court goes on to talk about the lies to the court and the lies to the United States Supreme Court. This is on page 9 and 10 of his order. The discovery process led defendants in May of 2025 to acknowledge an error, in quotes, in the previous filing. Defendants admitted hours before the scheduled deposition of the witness, who could allegedly verify the facts included in the prior declaration under oath, that in fact there was no such witness and therefore no reliable basis for the statements. While the court appreciates that mistakes obviously happen, the court was given false information upon which it relied twice to the detriment of a party at risk of serious and irreparable harm. Page 10. The court therefore affirmed its previous conclusion that they did not provide this person with proper due process and ordered his return. However, he was sent to the South Sudan. a nascent, unstable country to which the United States had recently told its citizens not to travel because of crime, kidnapping, and armed conflict. Yet they're sending migrants there. Then he points out another lie to the United States Supreme Court and or to his court. On the bottom of page 10, he says the U.S. government told the Supreme Court that because of this court's order, his court's order, that the Department of Homeland Security had to slam on the brakes while these aliens were literally mid-flight. I don't think that's how planes work, but slam on the brakes, thus forced to detain the class members at a military base in Djibouti. However, on May 21st, the day after the supposedly interrupted flight, ICE's assistant director for field operations testified differently to this court. Here's what Judge Murphy says, the court. And they ended up in Djibouti because of my order last night? Marcus Charles, no, Your Honor. The plan was to go to Djibouti and then from Djibouti continue on to South Sudan and go from there, sir. That's a lie. That was an actual lie. And they were still in the U.S. airspace when the court's orders came out. He then goes over the myriad of examples of the absurdity of the U.S. government's argument. Listen to this on page 27. Should an Ecuadorian woman have to know her risk of female genital mutilation in Somalia? In other words, well, they didn't object to going to Somalia, and they're from Ecuador. Sure, do they know about female genital mutilation there? Should a gay man keep himself apprised of buggery laws in the too long and ever-changing list of countries that enforce them? No person could reasonably be expected to make detailed prophylactic claims about every country on earth to which she might have a valid claim against removal. The burden should not be on those individuals. He says, accordingly, the court will issue a declaratory relief and vacate that March guidance as being inconsistent with due process. He did, however, have a little bit of his own fear of the United States Supreme Court and their ever-changing rules as it relates to the Trump administration. And they say, he basically says in the bottom of his order, I believe I should deny the stay, a stay of my order to allow the Trump administration to appeal. But given